Mandy Friedman here, licensed professional clinical counselor, clinically certified domestic violence counselor, clinically certified trauma professional level 2, and the creator of SNAP, Survivors of Narcissistic and Abusive Personalities. I'm here today with Melanie Mize, and Melanie is an attorney who works in the family courts. She is trauma informed and she understands abusive relationships. So she's basically kind of like a unicorn, and I'm really lucky to have her with us today because she's going to answer some interesting questions that come up a lot for our clients. Melanie, would you mind introducing yourself to our audience?
Sure. My name is Melanie Mize. I'm an attorney licensed in Ohio. My office is in Hamilton County. I practice family law, so specifically child custody matters, divorce, dissolution, things like that. I also work as a guardian ad litem and a mediator and parenting coordinator.
Awesome. Aren't we lucky? We are so lucky. I'm so happy that you're here with us today. I've got some questions for you. We are going to talk about a high conflict separation circumstance. Okay, so this is just a general umbrella topic of a high conflict divorce or separation that involves children, that also involves the courts. Now, this could be before the divorce or before the separation. It could be after the separation. And it could be that the courts have not been involved, but now they're about to be, or the courts have been involved the whole entire time. And we need to be documenting things. We have been told document, document, document. But what does that mean exactly? So how do we document? What do we document? And then what do we do with the documentation? And Melanie is going to answer some questions for us about that. So Melanie, in your work, what have you found to be the best ways to document? What are the methods of documentation that are the best methods?
The best methods are something that's going to be in writing. I have a lot of times when clients have things they've recorded, audio recordings, and sometimes those are very difficult to use in a court setting in a practical manner. Just introducing those into evidence, being able to identify who's talking on it, and that can be a lot more difficult than if something is written on paper.
So in writing is best. So we're talking about maybe keeping a journal. Is this a digital journal? Is it a handwritten journal? Should we keep it somewhere like in a file locked away? What should we do with it? Where should we keep it?
So the best way to keep something would be in some sort of electronic format so that it's safe. You're not going to lose it. It's not going to get found and then thrown away or thrown into the living room fireplace or something like that. So keeping something in an electronic format, especially if you keep it in a format that's on a cloud so that you can access it on different devices. So it's not just something that's saved as a note on one particular laptop you have, and then your hard drive crashes and it's gone. So being able to access that in different places would be best.
And the audio recordings, that introduces some things that could be problematic, like you described.
Sometimes audio recordings are great to have. But for the most part, they're a little clunky as far as using them in court for things, especially if you're having, say, a conversation with your kids and your kids' statements, they can't be introduced into court. That's considered hearsay. So when you have other people speaking in the audio that aren't going to be witnesses in court, then it's not as usable. So the audio, it gets a little difficult just from a procedural standpoint. The other thing I find when people start down that path of I'm going to record someone is they get a little maybe kind of hyper-focused on that method. And it can lead to situations where people are just constantly recording, and then they're kind of coaxing other people into certain conversations, and it can sound very manufactured, which winds up then hurting you in the long run.
Now, how frequently should we be documenting? You know, should it be just like a regular thing that we sit down and do? How much is too much? How frequent is too frequent? What do you think about that?
I think that's something that you want to consider as far as how much to document or when, is think about what are your big items that you want to make sure that you can relay to a court. What are, say, things that are important to the kids, such as their schedule or routine or things like that. You'd want to document those things. If the other parent has some sort of specific patterns of behavior that are problematic, those are some things to make sure that you're documenting when they occur. And it is best to document these things pretty soon after they occur, so they're fresh in your mind, and you're making that note, and you get as much of that detail as possible about what happened. I have people who will document parenting exchanges, for example. They make sure that on that day that that parenting exchange occurs, they've made some sort of note about it. Or if there's issues with whether or not certain things are returned for the child, or they've completed homework with the other parent, or those types of things, when you pull out those patterns of behavior that you think are important, those are the things to document.
Well, that segues us perfectly into the what to document. So we know that how to document is in writing, and also that the frequency is based on the events themselves and trying to record those in real time, so to speak, or shortly thereafter, so that it's all fresh in our memory. And also to decide what it is that you are trying to display through the documentation. What patterns is it that you're trying to show or convey? So that can help you figure that part out. Now, you mentioned several already, but then the next question is, what are the kinds of things that we're documenting? Are we documenting, you know, what mood the child was in that day when they came back from their parents? Or are we documenting, you know, what exactly was said? What were the words that were used? Because some of our clients will be, you use the word hyper focused, you know, hyper vigilant. Often will maybe go above and beyond with the documentation and go too far with it. They're putting too much into it. What are the basic things that we're looking for to document?
From the outset, you may document a lot of those smaller things until you're able to figure out where your patterns are. So you mentioned words used. Sometimes our kids come home using different words than they were using, and maybe it's just that they learned it at school or, you know, on YouTube or something like that. But there are times that you may notice a pattern of they've started using words that then the other parent is using in their text messages to you. And that could be a clue that this other parent is bad mouthing you to the kids, and then the kids are picking up that language and they're bringing it back home to you. So sometimes the words used by a kid are nothing. They're just, you know, part of growing up and learning language. But sometimes it's an important pattern to document. So at first you might not know what's the best thing. So you might document a little bit more than normal when you're starting out, and then kind of narrow that down as you go.
What types of things is the court looking at? What does the court care about?
Ultimately, the court cares about the best interest of the children, or that's what our statute is geared toward. And there are a number of factors in the statute that the court looks at. So for example, the physical and mental health of everyone involved, that is something that courts look at specifically. So you could choose to document things about whether or not the kids are coming home injured, or whether you send them with antibiotics for something and they come back with the exact same amount. And that kind of thing might mean that there's some physical health issues for the kids happening at the other parent's residence. You may also document similar things with the other parent. If the other parent is sending you messages that indicate that they may be having some sort of physical or mental health issue that affects their ability to parent, that's the type of thing to document.
What about the little stuff? Now, often high conflict oriented individuals have this way of just riding the line, just right in a sweet spot where it's not bad enough to do anything about it, but it's just bad enough to make your life more stressful and more difficult. How do we convey those sorts of items? For example, if every time you go to exchange the children, you'd mentioned just a second ago, the belongings, something doesn't make it back to your house, or they're 15 minutes late every time, or they pay the child support, but it's always 2 weeks late. Is there anything that can be done about these sort of needling issues that they're just really loving causing stress and issues for someone else? They're really just doing it to cause problems.
I'm going to give you just a famous attorney answer. It depends. Sometimes that is just, that's just something you're going to have to live with and deal with those little things and make sure you are not reacting to it, as hard as that may be. Sometimes those little things can be something that affects the child, though. For example, if with clothing, your child may decide that they're wanting to wear their favorite t-shirt they got at Disney World or something over to the other parent's home, and then that thing never comes back, or that thing is coming back with some sort of cut in it, or some sort of damage to the item. That may be a thing to keep track of, because that winds up affecting the child in the long run. So what you're looking at are things that go beyond just being annoying to you and really move into the realm of, are they affecting your kids? And that would be a thing to document. What the item was, what happened, and how that impacted the child.
This is really important because it's so complicated when a parent is being bullied or harassed or poked at by anyone else. It causes that parent stress to the degree that it could affect the children and the parenting quality that the children would be receiving from that parent. So when I'm talking to my client and they're saying, I get the money, but it's always late, so I never know when it's coming. And when I go to drop them off, they always have something to say to me, and then I'm triggered, and then now I have to go and take some medicine for that, or now I have to go and do this because my medical health is suffering from the stress, and then that's causing me to not be able to take the kids to all of their practices because I don't have the bandwidth to support them in their sports selections for this year. Our clients will think about things in this very complicated way of, well, it does affect the kids because it's affecting me, which then affects the kids. But it's an important distinction to make that that's not what we're talking about here. We are strictly talking about the best interest of the child, right? We're not talking about how the more, say, toxic parent or the more high conflict individual that might be causing problems. Sometimes it's everybody in this scenario. Sometimes it's just one person. Assuming it's just one person, they're not necessarily targeting the kid, they're targeting you. And then there's not much you can do about that. if it doesn't have anything to do about the best interest of the child, even though we can take it one step further and say, well, yeah, it is affecting them because I'm their main source of emotional support and nurturing. I'm their soft landing place. And now I am up to here and I need more sleep, or I'm so stressed out. So having to tweeze that out and figure out, how do we face the issues that we can handle and do something about, and how to face the issues that we really have no control over.
Yeah, you've kind of hit upon definitely a major issue in this area, that yes, the parent is being affected by that, and that does affect their parenting to some degree, but that is not necessarily what the court is going to look at or care about. A lot of this is just kind of reminding yourself of that serenity prayer, the things you can change, or accept the things you can't change. There was one thing you noted, that it does have an effect on the parent, and you could potentially show an effect on the child if there are these bills or expenses or child support or whatever it may be that the other person is supposed to pay, and they purposefully pay it, a week late or something like that, where you don't know when it's going to come in, and then you're trying to budget. If it's due on a certain date and they don't pay it on that date, that's a violation of the order. And it's the kind of thing where you wouldn't return to court every single time. That's going to make you seem a little petty, and definitely, I think, turn the court maybe a little bit away from you. But if you can document every time that happens and just save up enough of them and then file something about it, that is the kind of thing that it can have an effect on the child. You can't budget for, buying groceries because you don't get the other parent's half of some extracurricular. And so you're in a position as a parent to choose, do I keep my kid in the extracurricular that they love, or do I purchase groceries this week? And the whole reason that you're in that position is that the other parent is just refusing to pay on time. That is something that the court would be interested in.
Okay, so we're going to sum this up. First, when we document, we're going to do it in writing, and we're going to save it to a cloud so that it can be accessed from multiple places so that it doesn't get lost. The types of things that we are going to document have to do with the best interest of the child and patterns that we might have noticed or are noticing. And we want to document as much as possible in real time, or as close to the incident as possible, so that we have that information fresh in our minds. We're also going to think about what it is that we're trying to convey through the documentation. What's the issue that we're trying to illustrate? And that can help us figure out what's the important thing to be paying attention to, and what are the things that we can maybe let go of. And then lastly, we have to remove ourselves from the equation as that parent who may not be the toxic parent, the one who's having to manage all of this and do the emotional and mental labor and put up with the post-separation abuse that might be going on. We have to be able to separate ourselves out of that and really focus just on, how is this circumstance affecting the children? Well, Melanie, this is so helpful for my clients, I know, and I'm sure that it'll be helpful for your clients too. And we plan on making more videos like this because we have endless things to discuss. And I mean endless. There's so many topics that the two of us coming together, the legal perspective, the clinical perspective, we have things that will illuminate your situation and possibly guide you into a path of something that's healthier for you and your kids. Thank you, Melanie, for participating today, and we'll do it again sometime soon.
Thank you for having me. This was really exciting. I'm excited about what we're going to be able to do here.
Me too. And thank you for watching. or listening. Bye-bye.